you know exactly how meaningful they can be and how supportive they can be. So tonight we're going to be talking about emotional support animals. And if you've done clinical work, I'm sure you've gotten a request for a letter or for housing or for travel. And so we are joined by Karen Taylor, who's going to be walking us through understanding a little bit about disabilities and support and emotional support animals. And Karen has been providing training as an accessibility consultant at the California Department of Rehabilitation since February of 2019, where her primary focus is on how Americans with Disabilities, or the Americans with Disabilities Act, ADA, and the Fair Employment Housing Act, FEHA, applies to people with disabilities receiving equal access to programs, services, and activities. Karen has worked for the state of California for over 14 years. She's earned her master's degree in human development, education, and leadership, and has a bachelor's degree in child development from Pacific Oaks College. Her current specialties are employment law with a focus on disabilities, federal and state physical accessibility, as well as document accessibility. Thank you so much for joining us, Karen, and I hope all of you will warmly welcome her to our platform as we get started on this amazing topic.
So that's what we're going to go through. I'll try to go through as quickly as I can so that we can answer questions afterwards, because I try to get in as much of the meat and potatoes of this presentation, but I know that some questions won't be answered in here. So let's go ahead and get started. So I'm going to, provide an understanding again of what an emotional support animal is and what a service animal is. And then again, how does FEHA and the ADA and reasonable accommodation intertwine in all of these areas. So section 1 is the ADA and definition of disability. So very quickly, the ADA is basically substantially limits a disability. And another major difference between this and FEHA is that California law it's just to limits a disability. So record of such impairment, even if they do not currently have a disability, and who do not have a disability, but as regarded as having a disability. So this could be someone who has cancer and they've gone into remission, and but it's still episodic. You still are a cancer survivor. This could be someone who has a child at home who has epilepsy. If you're applying for a job, it could be, oh, wait a minute, I don't know if I want to hire this person because they have a child at home and they're going to be taking, time off of work. So these are areas that are protected by both laws. So the ADA, this is federal law and service animals. So basically it's any dog, and in some cases a miniature horse, that is individually trained to do work or perform tasks for an individual with disability. These service animals must be allowed in places of businesses if they are individually trained to benefit an individual with a disability. This does not include emotional support animals when it comes to public accommodations. This is the federal law. So the ADA and service animals. So Title I, I'll just briefly go through here. Title I of the ADA involves employment. So with employers, it's very different in that they can not allow a service animal or an emotional support animal. That it's called the reasonable accommodation process. You have to apply for the reasonable accommodation process to allow your animal to go into the employment arena. Title II and Title III are basically public accommodations. And basically for a service animal can go into any public accommodations that the handler can go to in any public setting. So FEHA And service animals, it is different. Service animals are animals that are trained to perform, again, specific tasks. You're noticing some similarities. And also know that service animals do not need to be professionally trained or certified. They may be trained by the individual with a disability or another individual. So then we're still talking service animals. So service animals are things like guide dogs or seeing eye dogs, hearing or signal dogs, psychiatric service dogs, sensory or social sensory or social signal dog trained to assist a person with autism, and seizure response dogs trained to assist a person with a seizure disorder. And these are service animals that are specifically trained for a specific task that it collaborates or basically is for that person with that specific disability. Very, very specific. So questions you can and can't ask about service animals. And this here is for public places only. This does not include employment. And this is where it gets tricky, is that if it's not apparent that this is a service dog, then you can ask these questions. You can say, is this dog required because of a disability? What work or task has this dog been trained to perform? And what you may not ask are about documents, certificates, details, or proof of the customer's disability or the dog's training. Entities must not probe about the disability or require documentation, proof, or training, or require a surcharge. So when a person goes to a hotel, they go to concerts, they go anywhere, and it is a service animal, they cannot make a person pay a surcharge. So again, with the public, this is concerning Title 2 and 3 of the ADA. It's very pretty much FEHA says the same thing. Service animals can be excluded if the dog is out of control and the handler cannot get the animal to behave, or the animal is not housebroken. If any of these situations occur, the handler can be asked to remove the dog, but the individual with a disability is still welcome to participate in the service or accommodation without the dog. So you're just removing, an animal that is not behaving, but you can still stay and enjoy whatever it is that you're doing at the time. So we're going to talk a lot about reasonable accommodation. So reasonable accommodation, and this is specifically for employment or for housing. So a reasonable accommodation is any change to the application or hiring process, to the job, to the way the job is done, or the work environment that allows a person with a disability who is qualified for the job and can to perform the essential functions of a job and enjoy equal opportunities as a person without a disability. And accommodations are considered reasonable if they do not create an undue hardship or a direct threat. So this is where a person can come in and say, well, there's a no pets policy, which does not apply to a service animal. Or you filed a reasonable accommodation for your emotional support animal, and I just don't feel comfortable with that, So the employer has to, or landlord has to prove an undue hardship. And that is defined the same way, the ADA and FEHA, and basically means that an action requiring significant difficulty or expense when considering the nature and cost of the accommodation, the overall financial resources available, the effect of the accommodation on other employees or tenants, and the facility in general, and the nature of the employer's operations. So if you had a service animal and they were aggressive, they weren't housebroken, I'll get more to emotional support animals in a few minutes, but the same thing is with them as well. So employment and service animals. So Title I of the ADA covers employment and SA service animals are considered a reasonable accommodation. So an employee or tenant, whoever, must request that the service animal be present as a reasonable accommodation for their disability. So that statement, I go back, that is for service animals. So here's a question. Do the same rules apply to a customer bringing their service animal into a store, govern a service animal accompanying an employee to their job? Well, as we go back of Title II and Title III of the ADA, service animals can go, most typically emotional support animals can go anywhere that the public can go, unless they're out of control, they're not potty trained, they're aggressive. But with and they don't need a reasonable accommodation. But with employment, they do. You must have a reasonable accommodation, and the same thing for housing. So again, in general, the employers are expected to grant accommodation requests if the employee's disability and the service animal function are related. So if you have PTSD, if you have a psychiatric service animal, and or you have epilepsy, and the dog is trained for specific tasks. So if they notice, they can sense when an episode is coming on, they're trained to go under the person as they're having a seizure, so that they can fall down on the animal and not hurt themselves. So, or an animal can sense if a person with diabetes, their sugar, their blood is fluctuating, and they can alert the handler. So the service animal has had sufficient training to not be disruptive presence in the workplace. They're not wandering around. If it's a service animal and they're working, you will most likely not know that they're there. They go most service. I know of 2 or 3 service animals that have gone through about 2 years of intensive training by an agency. But again, a service animal can be trained by their handler or another person. They do not have to be certified. And of course, the accommodation does not present an undue hardship. So who cares? So if you have an emotional support animal or a service animal at work, what are the responsibilities? And you get the reasonable accommodation. So the employee is responsible for the care and monitoring of the animal. The employer, however, may need to make accommodations that allow the employee to attend to necessary tasks as to where is the animal going to relieve themselves? Do they need a break to stretch just like we do? So the ADA, it does not specifically require for an agency or the handler to create a relief area. Just finding a place, even if it's a strip of carpet, even if it's what they call the puppy pads. A service animal can be trained to use an area that is paved, such as an alley. The employee is responsible for the cleanup of the animal. So public places and housing. So again, California laws allow people with a trained service animal to have full access to all public places and include any place where the general public can go, such as restaurants, hotels, theaters, shops, concert halls, etc. And the Fair Housing Act ensures that everyone has equal access to housing accommodation. So service animals and education. So this is where the ADA is a little different. The ADA permits a student with a disability who uses a service animal that meets the ADA definition of a disability to have the animal at its school. That includes the public, private, and federally funded institutions. For students under FEHA, does not apply in the school setting. Rather, it's the ADA and the Section 504 of the Rehabilitation Act of 1973. That's where that applies in the education setting. There's not necessarily anything under the California law, but it falls under the federal law. So here's some frequently asked questions of service animals, and the reason why I wanted to go through this is because um, a, a lot of people, not everybody, just don't know the difference and what the law states, what emotional support animal can do, what a service animal can and can't do, etc. So, do service animals need to be professionally trained? Okay, we went over this, and no, they do not. They can be trained by the handler or someone else. There's no certification process. Is a service animal that is in training provided the same protection as a trained service animal? And no, they are not. They have to be a full service animal. And do service animals have to wear a vest, patch, or special harness identifying them as a service animal? And no, they do not. Sometimes a harness is put on, especially if it's a guide dog. And that harness is for the handler to use as the guide dog is guiding them, especially in the public. So there's nothing that you can buy. There's no requirements to have the vest or anything. And who's responsible for the care and supervision? It's the handler. And does a service animal have to be on a leash? Well, this is same thing with the emotional support animal. Is they don't have to be on a leash, but they have to be under the handler's control. If they are not under the handler's control, then they need to be on a leash. If your dog is wandering, if it's becoming aggressive, anything like that, then it's, to me, it would be like, oh, that's maybe they're in training, or it just needs to be on a leash. So can a person bring a service animal with them as they go through a salad bar or other self-service food lines? Typically, with service animals, there are restricted areas where they cannot go through in public places, such as, food areas, certain areas in hospitals, like an actual surgery room or a prep room or anything like that, where it has to be sanitary. Because bottom line, these animals, they're still animals, and they have to abide by county and city and county laws as well. So does the ADA require, can a hotel charge a cleaning fee for guests who have a service animal? No, they cannot. Does the animal require to be certified? Again, no, it does not. And all animals, service animals and emotional support animals, depending on the type of animal, I would think, have to be vaccinated. And this applies to a service animal. Again, it's whatever your city, county, or state laws, and in your animal licensing, that's what you have to follow. And can a service animal be any type of breed of dog? And yes, there's no restrictions on whatever type of breed of dog that it is. So it just has to be under the handler's control. I know that sometimes things come up with the insurance, like sometimes for housing, there's insurance policies that restrict certain breeds, but under FEHA and under, the ADA, that kind of, there's protections for service animals. Falsification of a service animal. So California state law, and I'll go over this in a moment, with emotional support animals, they just passed a new law as of January 1st, 2022, that has more definitions of what an emotional support animal is, and some new laws, because there were individuals that were falsifying that their animals were either service animals, and that's where the TSA for airplanes they passed a new law where no longer emotional support animals can ride for free anymore. But we'll go over that in a moment. So this is also punishable as a felony or a misdemeanor, imprisonment up to 6 months or up to $1,000 fine. A misdemeanor punishable by a fine no more than $2,500. So there are laws against saying that you have a service animal and it's not. So barriers to support animals. So there's been an explosion of fraudulent animals, concerns about pets causing danger to their trained service animals, individuals and industries, just they don't understand the ADA rules and, the laws. And majority of industries and business owners, employees, and even myself, I didn't know really what a service animal was, what what they could and couldn't do, and especially how beneficial they are to people in general. I think I mentioned earlier that I don't have a service animal, but I have 4 cats and I have 2 dogs, 2 German Shepherds. And, I've been 100% working remote for the state for going on 3 years. And my personal anxiety, and also having the cognitive disorder of ADHD, it really exasperated over this time. And I tell you what, being preoccupied of feeding the cats and walking the dogs and having to care and nurture them along with my family, it kept me busy enough that I don't spend a lot of time on my own anxiety and my own mental health issues. So I am very thankful for my fur babies, as I call them. So now we're going to move on to section 2, emotional support animals. So let's just dive in. So California definition of disability, mental or physical disability or medical condition that limits one or more major life activity. So what I mean about a major life activity, that's seeing, hearing, walking, breathing, throwing, anything that could be one of those that is limited is going to be the definition of a disability. So you've had a history of such an impairment known to the employer. You're again, you have diabetes and you need to take breaks to do your insulin, and your employer knows about it. Also incorrectly regarded or treated as having or had such an impairment. This is, say, a person who is obese and a person, they're going for an interview and a person says, gosh, I don't think I want to hire that person. They probably have high blood pressure. They probably can't do a full day's work. So that's discrimination. Regarded or is treated as having such an impairment that has no presently disabling effects, but may become qualifying impairment in the future. So this is something that is episodic again. And the federal law actually changed. That's when the 2008 Amendment Act of the Federal Law came out to be more like California, because California's law is much more inclusive. So in the past, when someone had severe migraines, they had arthritis, in the winter, things that kind of came and went, or came and gone, I should say, then filing for, that you have a disability was very, very hard at the time. It just, unless you had an obvious disability, a missing limb, you were blind, things like that, or you're in remission from cancer. Oh, well, you don't have a disability anymore. Well, yes, you do. So that became federally, these are things that FEHA have had around for many, many years, and the California, and then the feds came in and said, you know what, we really need to expand our definition of disability and what's discrimination. So thank you, California. So emotional support animals. The ADA does not grant emotional support dogs owners the same right of public access, emotional support animals, I should say, the same right to public access that it gives individuals with support animals. So under the ADA, the owners of public accommodations are not required to allow emotional support animals, only service animals. From my knowledge, just from my knowledge personally, I have seen that expand a lot. There's restaurants now that are pet friendly. I walk into Home Depot, I walk into many other stores, and I just went into Costco the other day, and people are bringing their animals in. And I have not seen a misbehaving animal. So I'm perfectly okay with that. But the emotionally support animal um, provides, emotional, cognitive, or other similar support to a person with a disability to assist in managing the symptoms of their disability. And they are also referred to as comfort or support animals. An emotional support animal is not trained to perform specific acts directly related to the individual's disability, such as the service animal is. So, employment laws regarding emotional support animals. So, California's Fair Employment and Housing Act, FEHA, requires employers to make reasonable accommodations for employees who wish to have their emotional support animals accompany them to work. Again, it's about reasonable accommodation. Employers may request that their employee provide a letter from a qualified medical professional explaining that their emotional support animal is part of their treatment. So the U.S. Department of Housing and Urban Development states that any breed, size, weight limitations may not be applied to an emotional support animal. So, basics of how to request a reasonable accommodation from work, preferably in writing, a request to bring an emotional support animal to work. You basically need two things: that the California worker is a person with a disability, or say the tenant, they require an emotional support animal at work as a reasonable accommodation to perform their job functions. Say if someone has anxiety, they especially things like panic attacks. I can certainly relate to that. Just having an emotional support animal, available, I call it my cognitive behavioral therapy. Is that it snaps me out of whatever I'm doing. I have 4 cats, and between the ages of 3 and 6, and half the time they're running around, there's territorial issues. And if I'm not feeling well, I'm immediately distracted. If one cat is being territorial, I'm running over there, breaking up fights, and then I'm not thinking about what I was panicking about, something I didn't have control over. So, I can certainly relate. So, employers and reasonable accommodations. So, employers can't just say no to a reasonable accommodation request. The employers, they have to called what's engage in the interactive process. And this is a dialogue. This is an exchange of ideas about what reasonable accommodation would make it possible for the person to do their job effectively. So also note that the solution must be specific to the job, the person, and their disability. The employer must approach the discussion, and this is very important, in good faith and work with the employee to find and ultimately provide a reasonable accommodation. Also know that it's an exchange. The person requesting the reasonable accommodation, they're their own best advocate. They may have strategies that work at home that might transfer to the work environment. um, and then you can bring in the medical doctor and ask them, well, what do you suggest? That, and the employers do not need to know what your disability is. uh, the medical doctor only has to let them know what the reasonable accommodation is regarding your limitations to make you perform your essential functions of your job effectively. So employers may either grant the request uh, upon the worker meeting certain conditions, or you go back to the interactive process to determine what alternative reasonable accommodation exists. So it's basically it's a dialogue. You're working together to support this person in completing, to be an individual, competent employee and a happy employee. Employers, they'll usually perform an individual assessment that considers the work environment. Sometimes it's ergonomical. They're reviewing what duties you have, the type of business a person engages in, and the person's position. Uh, and then they also have to look at, will this cause an undue hardship, that by allowing this reasonable accommodation, will this incur significant difficulty or expense for the employer when considered under the whole totality of the circumstances? So they're going to look at, what's the cost of the accommodation. If it's going to be, well, I'll just give a made up example of, if a person is requesting that a lift be put in a small mom and pop store. The store is, they have the storage on the second level because the employee cannot make it up the stairs, and there's only 3 workers, and the net income is probably, is as much as the lift costs. Then that could be, hey, that would be a financial burden, that would be a financial hardship for the agents of the employer to say, okay, we're going to install a lift. So the employer may not rely on a no pets policy in denying workers for an emotional support animal as a reasonable accommodation, because someone could say, basically that's a policy. And with emotional support animals and service animals, it's the reasonable accommodation. If there's a policy, someone has allergies, one disability does not trump another. So you would work with that other person as a reasonable accommodation, maybe. And we had this happen at our job. So what would happen is the service animal would take the opposite way to the elevator, going around the other person's cubicle, and then they move the other person on the other side. We actually had another open cubicle so that they could provide some distance. So just because, well, I can't have this emotional support animal in here because I'm allergic, well, then you need to treat that as a separate reasonable accommodation. So housing, landlords must consider emotional support animals if the tenant has a qualified disability and documentation, and they go through the reasonable accommodation process. Again, landlords cannot charge pet deposits or fees or raise rent for an emotional support animal, and must only provide a reasonable accommodation for a tenant's disability. So there are limits to emotional support animals. So the animal doesn't make a direct threat to others or property. Again, undue hardship, and doesn't fundamentally change the types of services the homeowners association or landlord provides. And then California qualifying types of emotional support animals include a dog or other animal not specifically trained to perform acts to assist a tenant or a person's disability, whose owner gets a sense of calmness, safety, or well-being from the animal's presence and companionship. Education, students may request a reasonable accommodation to have their emotional support animal allowed in a college setting. If the reasonable accommodation is approved, then the emotional support animals are typically not allowed in areas such as dining facilities, classrooms, labs, and individual centers. So there are restrictions, just like I said, about going through the lunch cafeteria line. Typically not allowed. There are certain areas that service animals and emotional support animals just can't go to. One difference I do want to say is if they were to say service animals or emotional support animals are not, an example would be allowed in the pool. Well, of course, but the service animal could go and sit on the patio or sit outside of the pool for their owner, but maybe an emotional support animal wouldn't. That would be on a case-by-case basis. So documentation for an emotional support animal, housing providers can request for a reasonable accommodation. Basically it's a reasonable accommodation and just have documentation. The tenant is not required to disclose their disability and only disclose if an emotional support animal is needed. Again, a person does not have to disclose their disability. You could, say from a medical doctor, they could say, they need, a reasonable accommodation for emotional support animal. But sometimes you do have to disclose what the disability is. I'm thinking more of a work environment. You might go to HR, but your direct manager only knows the accommodations that they need to provide, and maybe only HR knows, from the letter what the actual disability is. So it's on a needs to know basis. It's case by case. Reliable documentation of individuals' disability and or their need for a reasonable accommodation. Looks like I have a little typo there. I apologize. So common refusals. The animal's too loud. The coworker is allergic to emotional support animal. Again, if you know the law and these are common, and you can say, well, that, then they need to ask for their own reasonable accommodation. I shouldn't be, it is against the law to do that, period. Creates an indoor indecent odor or offensive to the senses. So the animals have to be clean. That bottom line, the emotional support animal is a dangerous breed. Now, remember, emotional support animals can be any type of animal. So it's probably about 3 years ago, I read an article. A gentleman was moving to a retiree home, and he wanted to take his emotional support animal, which was an alligator. So, it was denied, and I don't really have to go into details about it, but just something like that, is pretty obvious. But I'm sure there's other cases that's not so clear. If the animal's too loud, you can propose a humane bark collar or complete an animal training. If the coworker is allergic, just like I said, propose to relocate the employee, get HEPA filters. If it's an odor, you need to verify that the odor is from some other source. If it's true, prove that the emotional support animal is clean, bathed regularly, and odorless. And again, the ESA can be any breed, size, or weight and is not subject to employer limitation. But again, if it's something like an alligator, it's something like a chicken or a duck, things like that, if it's clucking or making too much noise and it cannot be controlled, then those are reasons to deny. So the new laws, so on January 1st, California enacted new emotional support animal laws. And so anyone selling emotional support dogs must provide written notice that the dog does not have the training required to be a service animal. And then when it comes to paraphernalia, anyone selling certifications, IDs, tags, vests, leashes, or harnesses for ESAs must give the same notice. And then for healthcare professionals, requirements to issue emotional support letters, you must hold a valid active license and include the details of this emotional support animal documentation. And you must have an established relationship with the client at least 30 days before issuing the emotional support animal documentation. And then the Air Carrier Access Act, reasonable accommodation only applies to service animals as of January 1st. Emotional support animals may be able to go if they are in a carry-on that would store under your seat, and pets must be small enough to qualify, and a fee is typically charged. To file a complaint, if you feel that you've been discriminated against, you can come file a complaint with the United States Department of Justice or by calling the department. You can also file a complaint with the California Department of Employment and Housing Act. Or you can file a lawsuit with your state or federal court. And a lot of resources that I pulled this information from. I'm still not quite done. And I'm open for questions.
Much for
Sure.
all the information. We were kind of chatting in the back, like, wow, this is new. A lot of this is like brand new
Right.
from January. I guess technically we're 5 months in and we should know all these things.
Well,
but
it's new. It's new. And for the law, it's new.
Yeah. So I think in many ways, like throughout your discussion and presentation, you talked about the justification why we should have pets be present for folks who have disabilities and struggle with emotional regulation. And I think the letters really do clarify like what the purpose of the pet is and how they can serve this individual best. I'm just curious if you also you talked a lot about what the differences are between the emotional support animal versus the service animal. And I think that is a very key difference that clinicians like us should know. Unless you are actually training an animal to do specific tasks for individuals with disabilities, they're not going to be a service animal. Or am I saying that correctly? Yeah,
yes.
They'd be a service animal. They would be a emotional support animal.
Yes.
One of the big things that I know I have encountered and other clinicians have encountered are concerns about writing letters for emotional support animals because of lawsuits. We're worried what can happen if the dog bites someone? Are we liable because we're writing that this is an emotional support animal? And I kind of think you address some of that with like recognizing that this animal is not trained specifically to provide a dedicated action for that disability, but that they are comfort. I'm just curious if there are other thoughts that you have in relation to that anxiety that many clinicians have.
Well, I can't really speak upon that too much. I can give you my personal opinion in that it's really up to the handler. I mean, I would think because they have certain rules and laws that they have to follow. And the number one is that it's under control. Do they have the animal under control? And is it on a leash? Is it not on a leash? And, so you really, the pet owners have to take responsibility for that. I don't know the law regarding letters or your position. I would imagine that, interviewing this person, you're diagnosing this person, and this is what they're telling you. So I would think on a good faith effort that, you would be doing your part, but the other, the pet owner, they have to do their part. So, but that's something that you have to look into your own legal department, and I definitely would.
Yeah, no, I appreciate that, because what it does is it puts the onus on both the clinician and the pet owner, or the person you're prescribing an emotional support animal to, because you cannot predict. The same thing with violence potential in people. We can't predict what is going to lead someone to become aggressive. Can't predict when this animal is going to become aggressive or not. But you did specify the importance of being able to control the animal, or have control over the animal. It also not be an animal that is a threat in many cases. Like an alligator, can you train it? So things like that I think are really important. I love that you detailed what things can and cannot be asked. I think a lot of us were not quite sure in terms of what is appropriate to ask, like not having to list the diagnosis, but just state you're requesting a reasonable accommodation. In my own personal experience, I had a landlord, I believe it was the landlord, ask what specific symptoms the dog, or it was a dog in this case, would be able to address. And I was kind of like, I give you some symptoms, you're going to figure out what the diagnosis is. So, you kind of sometimes feel like you're torn. Of course, I had to consult, but even the attorney that I had at the time, they weren't 100% sure either. So
they're not allowed to ask questions like that, because if they're asking, okay, so what is it? And you could say, okay, well, it's for depression. And they're thinking, oh my goodness, are they a non-medicated person with, bipolar and depression and ADHD? Are they hearing voices? So already the discrimination is happening. They're just trying to solicit information from you as to, okay, they have a disability. Does that mean that they're crazy? Does that mean that they're X, Y, and Z? And they can't do that. I mean, they just, it's against the law.
Well, and I appreciate you highlighting that, because as clinicians, we're trying to do what's in the best interest of our clients so that they can be supported and functional in their everyday life. And so, it sounds like consult.